recorded and then posted on the core webpage. So you can view it later, or you can also invite other people to view it for the information that's shared. A few housekeeping rules or suggestions. I don't like rules, so they're more suggestions. You are able to mute and unmute yourselves, and you are invited to leave your camera on for the presentation. However, if you find that connectivity is an issue for you, especially if you're joining us from rural parts of the province, if connectivity is an issue for you, you're welcome to turn your camera off. We do ask that you mute yourself, though, for the time of the presentation. And if you would like to ask a question or have a comment, use the icon at the bottom of your participants toolbox to raise your hand. We have Chantel Ottenbright here from the Alberta Elder Abuse Awareness Council, who will be monitoring the chat box, and we will spend some time towards the end of the presentation to address the questions and perhaps take some of the comments that people share. So again, yes, question and answer. Hopefully, if we have time at the end, we will address that, and our wonderful guests will be able to stay with us to answer those questions. Cindy Wing from the Core Group Technical Division, that sounds really formal, is here, and she can provide anybody with some any technical support that they might have. So if you're having issues logging in or checking in or joining us today, please, if you can, send her a direct chat message that you're having trouble, and she'll hopefully be able to help you problem solve that. So having said all of that, thank you again for everybody for joining us. And I would like to now introduce our wonderful guest presenter, Melanie Blackwell. And Melanie has worked in the community services field for over 40 years, both in the public and private sectors. 26 of those years with the government of Alberta. She has a Bachelor of Community Rehabilitation degree from the University of Calgary, and she hopes to soon complete her master's degree. She has been with the Office of the Public Guardian and Trustee for more than 16 years, and the last 8 years have been spent in Calgary as a capacity assessment policy analyst and complaints officer. She has a wonderful husband, and those are her words, and I don't have any reason to doubt, of 24 years, an 18-year-old daughter with developmental disabilities, and a 20-year-old daughter in her second year of criminology at the University of Alberta. And in her free time, I can't imagine her having any, but in her free time, she's dedicated to animal rescue, which is one more reason to love her. And she fosters and volunteers within the animal rescue world, and has adopted 4 of those lucky rescues. So thank you, Melanie, today for joining us. You can unmute yourself, and I am going to stop screen share now, and I'm going to give the control over to Melanie so she can take us through our presentation. Welcome, Melanie.
Okay, is that sharing my presentation now?
We can't see it just yet, but you just take your time, and I know it'll show up eventually. We're pretty easy going group here. So.
Is it showing now?
Not yet.
Okay, well, what am I doing?
Did you click the share screen button on Zoom?
Yeah, I did. I might be sharing the wrong screen though.
That's okay.
Of course, I did this 2 minutes ago and it worked, and now
we did. We had it down just like troopers, and now that y'all are watching us, yeah, that's okay.
And I always have to play with everything and fool around, and then it doesn't.
Yeah, I know. I do that too. Take your time. We'll get the presentation up shortly. You just it'll work. I know it will. I have all the confidence in the world. And if not, I can put my screen back up and we'll go from there, and you can just tell me to click the slides forward.
Yeah, you might have to do that because I'm not sure what I'm doing.
You want to do that? Okay.
Sure.
Let's do it that way. Here we go. Okay. I am on your first slide. Can you see
Okay.
that, Melanie?
Yeah.
Okay. Okay, very good. How about her? And just let me
Okay,
know when
thank
to
you.
advance the slide.
And thank you very much, Charlene, for inviting me to do this. And it was nice to see some familiar faces on here that I've worked with over the years. So that's always good. And I have to give my disclaimer when you said I'm a rescuer. I give no guarantee that there will not be a fur butt go across the screen every once in a while. One of my troublesome adoptees decides he likes to walk back and forth on my computer screen and my keyboard. So we'll hope that doesn't happen, but we'll see what happens. So I think to start out today, I just wanted to talk to you a bit about what the Office of the Public Guardian and Trustee does, and then we'll go into a little bit about what capacity assessment is. So next slide, please. So just a little bit about the Office of the Public Guardian and Trustee. We used to be two separate offices that did some work together under the same acts. The Office of the Public Guardian is mostly guided by the Adult Guardianship and Trusteeship Act, the Personal Directives Act, and the Mental Health Act. The Office of the Public Trustee is guided by also the AGTA, the Public Trustees Act, the Wills and Succession Act, and the Minors Property Act. So given all of that, and we were under two separate ministries, and then we were under the same ministry, and now we're all one program. In 2014, we merged to become the OPGT instead of two separate offices. And we are under the Ministry of Justice and Solicitor General now, and I think probably we'll stay under that ministry, but who knows? We've been under pretty much every other one in the province too. So we still do have some clients in common. The public trustee works with some represented adults and manages their finances. So we have those clients in common in general. So some of the processes are the same, like our intake process and our referral process is supposed to be the same, but it's always kind of fluid, trying to figure out what works the best. Next slide, please. So one of the my title officially is Capacity Assessment Policy Analyst and Complaints Officer. So I handle everything that has to do with capacity assessment and all the workshops and field all the questions that have to do with capacity assessment and training. And my role as the complaints officer is I receive all complaints that have to do with guardians, trustees, co-decision makers, and agents on personal directives. So two pretty big roles, but mainly today I think we're going to talk about capacity assessment. So during COVID, all of our courses and workshops are virtual because of travel restrictions and people working from home and just not being able to have group meetings. That will be until further notice is pretty much all I've been told, that it will just continue to do that. Generally, each course that I do is offered once a year when it's possible. This last couple of years have been a bit mixed up with new government budget changes, and then of course, the pandemic hits just to make everything fun. So, you know, it's just when I can do them, I get them in, and when I can't, we just hopefully can get as many as possible in the next time around. Right now, we don't charge a fee for our courses, but we will be in the future. We did some research and found out we were the only ones not charging for workshops. Being that we were government, we didn't think that we were supposed to or that we were allowed to, but apparently we are. It'll be a minimal fee, and I'm not sure when we will get that organized because nobody seems to know either how we're supposed to do that. So right now, all the courses that I offer are free, but probably by 2022, we will have a fee for them. Next, please. Okay, so I'll talk to you a little bit about what the Adult Guardianship and Trusteeship Act is. That's our biggest act and the main one that that we work with. So I'll give you a bit of a quick explanation of how that act works, and it will give you more of an idea of why capacity assessment is so important. So next, please. So I think I might be having a little bit of technical issues here, but we'll see how it goes. I might have to bring it up myself. So this act, the Adult Guardianship and Trusteeship Act, better known as the AGTA, came into law in 2009 and replaced the Dependent Adults Act, which was a very old, not very effective act. And with the changing way that society worked, it just wasn't a very effective act anymore. So it was completely repealed and replaced with the Adult Guardianship and Trusteeship Act, which we based on 4 main guiding principles. The first one being that capacity is to be presumed. So every adult, which is anybody over 18 in this province, is presumed to have capacity until it's proven otherwise or until a court says otherwise. The second principle is that communication method is not relevant to the determination of capacity. So that means that it doesn't matter if they have a language barrier, if they're hearing impaired, if they have a medical condition that interferes with their ability to communicate. That does not affect the determination of whether or not they have capacity. The third one is that autonomy is to be maintained through the least intrusive and least restrictive measures. And this is something that's really important when it comes to capacity assessment, because we want everybody to have as much autonomy as possible. So guardianship, trusteeship, any of that is a last resort. We want the person to be able to speak for themselves as much as they possibly can in the least restrictive and least intrusive way possible. The fourth one is that decisions made by the decision makers are to be in the best interests of the person and how that person would make those decisions if they were capable themselves. So it's not the decision maker's best interest, which is, when it comes to my complaints rule, that tends to be what happens a lot, is I want that person to have the decision that works for me, not necessarily what works for them. And that's where we get a lot of complaints from. Next slide, please. So this is the continuum of how decision-making works under the Adult Guardianship and Trusteeship Act. And this was probably one of the biggest changes from the previous act, where under the Dependent Adults Act, you either had capacity or you didn't. And if you didn't, then you got a guardian or a trustee. Under this act, and to maintain people's autonomy and their ability to have different levels of capacity, we made things work more on a continuum. So at the beginning, people have full capacity, they can make their own decisions. And then there's supported decision-making, which is the person has capacity to make their own decisions, but they may need a little bit of assistance from somebody, say when they go to the doctor. My grandma was 93 and I would go to the doctor with her and just make sure that she understood what was being said, because she was hearing impaired and didn't like to admit that. So sometimes she would nod her head and say she did get something when she really didn't. So this is basically an informal process, but it does help people. You know, a lot of times people will use this with pharmacists who don't like to give out information to anybody. And if they have a supported decision-making authorization document, they can go in and say, you know, I need to know what my grandma's medications are and what they're for so that I can explain it to her. Then we move into co-decision-making, which is, I'll explain more of these a little bit later, but co-decision-making is the first court-ordered level of decision-making that we have, where a person has severely impaired decision-making ability, but they can still make some of their decisions along with somebody else. So 2 people are named as the decision makers and make those decisions together. And then over to guardianship and trusteeship, where the person lacks capacity and has a court-ordered guardian or trustee named. The other 2 are specific decision-making and emergency decision-making. Specific decision-making is when somebody just needs a one-time decision, generally placement. into a long-term care facility or a residential facility. Emergency decision-making is when somebody goes into hospital or needs an emergency treatment and a doctor can make the decision to do that treatment if they can't find a decision maker, don't know if there is a decision maker. Temporary guardianship and trusteeship is if we need to do an urgent application to court if somebody's being abused and needs urgent protection. So that's kind of a quick overview of what the continuum looks like. Next slide, please. Excuse me. So co-decision making we talked about a little bit already. And the adult is capable of making some decisions, but their ability is impaired enough that they need someone else to make decisions with. This is the first level that requires a capacity assessment report, and it's called a Form 3. The co-decision maker is generally a family member or a friend trusted by the adult. So the adult has a lot of say in who their co-decision maker is, and we want them to be able to have somebody that they trust, not, their estranged father that they haven't seen for 20 years. We want it to be somebody that they're going to be able to work with to make their decisions. A co-decision maker cannot be the public guardian. And we'll see when we get on to guardianship and trusteeship that can be the public guardian or trustee, but in co-decision making, it cannot be the public guardian. You also cannot have a co-decision maker and a trustee, which gets really confusing to people. And I'll explain why when we get to trusteeship, but if you have a co-decision maker, you cannot have a trustee. Next, please.
Sorry, there seems to be a bit of a lag between the slides.
Yeah.
Melanie, is the next one up for you now?
Yeah, it is.
Okay.
So guardianship is the next level that's court ordered. And this is when a person does not have capacity to make their own decisions and they would have a guardian appointed by the court to make their decisions for them. It doesn't necessarily have to be in every area of the life. There's 8 areas on a guardianship order. They can have 1 or 2 or all of them. It just depends on the domains that they lack capacity in. And that's where a capacity assessment report really comes into play, because they've been assessed in those areas. So we know where they can make their decisions and where they can't. A guardian can be a family member or a friend, or if there is nobody that's willing or able to do that, the public guardian can be appointed. Public guardianship is definitely the last resort that we want to have appointed. We always hope for there to be a family member or a friend first, but that's not always the case. And sometimes those family members, even if they have them, are not the best people to be a guardian. This level, in order to have a guardian or to even go to make a court application, the person has to have had a capacity assessment done. And the capacity assessment report is called the Form 4. We normally refer to them as a CAR. In order to do that assessment, though, first, a person has to have had a medical evaluation within 3 months prior to the beginning of that assessment. And why we do that is to rule out that they're not suffering from something that's temporary or that might be just an issue that they're having right now, or they might be acutely ill right now with mental illness. And we want to make sure that they're at their best to have the assessment done. So we want them to have a medical evaluation saying that they're not suffering from a temporary issue that's affecting their ability to make decisions. Often one of the examples we use is a senior that might have a bladder infection or something like that can really affect their whole system and their ability to make decisions. So we want to make sure they're at their best. These are used for co-decision making, guardianship, and trusteeship. All 3 of those have to have that medical evaluation. The medical assessment can be completed by a physician, and we recently just added nurse practitioners to be able to do that. We were getting a lot of requests for that because often I think nurse practitioners do a lot of that work anyway. And previously, because they're regulated forms, we weren't allowed to change it until we actually went to the legislators and did a review of our regulations and got that changed. So we jumped in and pushed that one and got it authorized so that now a nurse practitioner can also be the person that does that 3-month medical assessment. Next, please. excuse me if my voice gets a little cranky today. I've been kind of trying to fight off getting a cold, so. Okay, and I am moving through these fairly quickly just in the interest of time. So at the end, you may have some questions about them, but the next level is trusteeship. So a person can have, again, a private trustee to manage their finances. Trusteeship is just financial matters, or they can have the public trustee if there is no family that's able to do, to take on that role. The reason that you cannot have a co-decision maker and a trustee is because with trusteeship, when they wrote the act, they decided that there's no range of capacity in trusteeship. You either have the capacity or you don't. So it didn't work with co-decision making where you can have a range of capacity to be able to make decisions under that section. So we are hoping someday to have this changed, but so far we're still stuck with they cannot have a co-decision maker and a trustee. The represented adult can have a guardian and a trustee, or one or the other. So if they have a guardian, they can also have a trustee, or they can just have a trustee, or they can just have a guardian. Something to mention with all three of these levels, co-decision making, guardianship, and trusteeship, is that we can now start application at 17. This was new when we did this act as well, because prior to this, nothing could be applied for before the person turned 18. That included AISH and PDD and nothing could be applied for. So we had to wait until they turned 18, start the whole process, and then get their decision makers put into place. So now when a child turns 17, they can have that capacity assessment. All of the documents can be done and go to court, and the order can be granted, but then it just remains dormant until the day that they turn 18. And then there's not that lag in between where, you know, we often had difficulty with who's going to make a decision for them. Now in between they turn 18 and they become their own guardian, and we get a guardianship order in place. Next, please. So on to specific decision making. Now, this is not a court-ordered process, and the public guardian is generally not involved in these unless there's nobody within the family that can make the decision. So this is when there is no guardian and there is no personal directive with an agent named under that personal directive to make their decisions. So this is somebody, perhaps a senior, that is not really in need of a guardian and may not have made a personal directive, but they need either placement into a residential facility or they need a medical decision made, and they don't have somebody that they don't have the ability to understand how to make that decision for themselves. So the physician would do an assessment and select somebody from a ranked list, which is listed in the, I believe it's in either the regulations or the act, that starts with like the spouse, the oldest adult child, and they work through that list. I don't think most physicians work too far through the list because it's a very time consuming, but hopefully that person has a good family relationship that they can select somebody from that can make that decision. And it's meant to be a one-time decision just to help them get through that first decision and then decide if they need more formal decision-making after that. The form that's completed is called a Form 6, and these can be filled out by a physician, a nurse practitioner, or a dentist. Lots of people think that it's kind of strange to have a dentist, but often that medical decision that a person might need or a healthcare decision is to have dental work done, but they can't really understand how to give consent for that dental work to be done. So I'm not sure that dentists really have ever done these very much, but they do have the authority to make them if we need them to. As I said, the only two decisions that can be made under this authorization are a healthcare decision. So it might be a treatment plan for diabetes. It might be that they need to have a surgery that they don't understand the ramifications of having or not having that decision. And the second one is temporary admission or discharge to a residential facility. So In general, the decisions are from acute care to long-term care. It might be a group home. It might be just another form of a residential facility that they need to be moved to. But generally, we move them from acute care to the facility that they're going to. Specific decision-making cannot apply to psychiatric treatment decisions for formal patients because that comes under the Mental Health Act with decision maker of last resort, and end-of-life decisions such as removal of life support. When we first started doing this, we very often got calls from physicians wanting us to authorize removal of life support, but the Act does very clearly say we cannot authorize that under a specific decision-making authorization. Next, please. I'm not sure there we go. So continuing on with specific decision-making, if there's no one available from that ranked list, the physician can ask the public guardian to either name someone else to make the decision, or the public guardian can make the decision themselves. This is the only time that we're involved in these. They don't have to get sent to us, or we don't have to know about them unless they involve the public guardian to begin with. If there's a dispute between, like say, for example, the only person somebody has is a son that they haven't had a good relationship with, or that they don't want to have anything to do with. If there's a dispute like that, or an issue between the one decision maker, then that might be an incident where the physician would call and ask the public guardian to make the decision. I was just doing a presentation this morning, and we were talking ordinarily, if we were asked to make that decision, we would have to go and meet with the person first to talk to them about the decision. And then I'm talking about the person that needs the decision made. So we would go and meet maybe with that senior and see, what their thoughts are, get their opinion. But given COVID and the travel restrictions and everything else, that's been changed so that we don't have to meet with them in person anymore. Whether that will change after COVID, I'm not sure, but it does make it much more effective for us to be able to make those decisions when we can't go and see the person. The Form 6 can, like I said, can only be completed by a physician, a dentist, or a nurse practitioner, not a designated capacity assessor. And we'll get more into that when we get a little bit further in. So next, please. So we'll talk now about the actual capacity assessment. The others were all sort of your forms of decision-making that can occur. And now this is when a capacity assessment is needed. Next, please. So in order to become a capacity assessor, there are only 4 professions that can do this. And these are named in the Adult Guardianship and Trusteeship Act. So it's not just professions that we picked out of our hats. There was a lot of research done, and we went with we looked at how other provinces and other places do their capacity assessments and who can do them. We didn't want to open it up to just anybody to be able to do, or any medical profession, because it's just way too hard to monitor them that way. And we are very particular to monitor that people are maintaining their competencies to do these. So registered social workers, registered occupational therapists, registered nurses, and registered psychiatric nurses are the only 4 professions that are authorized to complete these after they've completed the 3-day mandatory course and passed the final exam to do that. Once they do that, I send their names up to the Minister of Justice, and he designates them as capacity assessors. Only when they get that designation can they start doing assessments for co-decision making, guardianship, and trusteeship. They're only designated for those 3 decision-making types, and only under the Adult Guardianship and Trusteeship Act. They are not designated under the Personal Directives Act because it's a different act, and that act does not have any allowance in it for designated capacity assessors to be able to do the assessments. So specific decision making is also not one of the ones that they're allowed to do. They clearly specify that they want physicians, dentists, and then the confusion comes where nurse practitioners can do them, but they can also be a designated capacity assessor. Next, please.
Melanie, I'm going to try something. I'm going to give you remote control of the mouse.
Okay.
And see if that helps, because I know we're doing fine, but I know it must be frustrating for you. So I'm going to give you control of the mouse and see if that works better. And then just go down to the yeah. Are you able to control the slides that way? You're rolling through them?
Oh, yeah, I'm still getting a real delay for some reason. I can,
okay.
But so we'll just leave it like this and I'll stuck between two slides right now. I'm not sure why it's doing that.
I'm not sure either, but the world of virtual presentations, and we're all very, we're very forgiving of one another. So you're doing great. Thank you.
Okay, now I gotta find where I was. Okay, so under the regulations of the Adult Guardianship and Trusteeship Act, the other two, I switched to a slide. The only other two groups that are allowed to conduct capacity assessments are physicians and psychologists. They are grandfathered into the Act to be able to do assessments without specific training or specialized training. They don't have to get designated, they can do the assessments. What we found when we started doing that was that physicians and psychologists were saying, I don't want to do that. I want some training first before I'm comfortable doing the assessments. So we did develop some 2-day workshops for physicians and psychologists. They're two separate workshops because some of our physicians here in Edmonton work to get the physicians colleges to apply educational credits for them, but they won't allow anybody but physicians into the workshops. So we do offer 2-day workshops for physicians, and then I have another 2-day workshop that we do for psychologists. And we found them to be very effective and very full every time I offer one. There's always lots of people that want to take them, and we appreciate that very much. And I appreciate that if they're not comfortable doing them, that they ask for some more information and training first. I get tons of phone calls from psychologists and physicians just asking questions about when they can do an assessment or how to do it or what certain things mean. So, you know, the more education we can get out there, the better. Those workshops that I do with physicians, I have a group of physicians that also does part of the training. That was also part of the requirement by the colleges, but we would have done that anyway, to have the physicians come and help do that. So when we do capacity assessments, we want to make sure that the person actually needs one. Lots of times family members will say, you know, this person is making bad decisions, so they need to have a decision maker, and that's not necessarily true. So we want to make sure that they're always the last resort, or that they're really, really necessary to do, and that we can't do some problem solving first that would eliminate that need for a capacity assessment, and them having an informal process in place that helps make their decisions without having to get a court order. So the capacity assessor is expected to do the assessment in accordance with the regulations and complete the capacity assessment report. It has to be in that prescribed form. We cannot use any other forms. We cannot adjust the forms or change them, which is why they're always in PDF, not Word, so that nobody can change them. They're in the regulations that way. So even when we wanted to make the change to nurse practitioners being able to do them, we had to wait till we could go to a legislative change to be able to do that. capacity assessments, like I said, are required for co-decision making, guardianship, and trusteeship, whether that's an initial application or whether it's a review of an existing order. The exceptions where we may not have to have a capacity assessment are sections 27 and 48 for guardianship and trusteeship orders in urgent cases. So if somebody's at imminent risk of harm mentally or physically or financially, we can ask the court to do an urgent order without having a capacity assessment done at that particular time. Just waiting for the slide to appear. Strange. So the next slide is what the definition of capacity is in the AGTA. And this is a common definition throughout virtually every guardianship and trusteeship office that we looked at when we were developing this process. So capacity means, in respect of making a decision about a matter, the ability to understand the information that is relevant to the decision and to appreciate the reasonably foreseeable consequences of a decision and a failure to make a decision. So it's not just can they make a good decision, but can they understand what the decision is? Can they understand the consequences if they don't make that decision? One of the common examples, and Chantal, you've probably heard this one before, that I came across when I was starting to do some of this training, was a gentleman that had diabetes and needed to have a leg amputation, or he would die without that amputation. And the doctors and the family really wanted us to force him to make that decision, or force the decision on him that he had to have that. But he completely understood what the decision was, that they wanted to remove his leg, and that if he didn't have that removed, he would die. And he said, I would rather die with 2 legs than live with 1 leg. So, he understood what the consequences were, and that's, we didn't have to make a decision for him in that situation. There's a question from Karen that says, does a capacity assessment need to accompany an application for guardianship and trusteeship? Yes, it does. It becomes part of the court application. Capacity assessment, I should also say, is what provides an opinion to the court, whether the person has capacity or not. You're not making a diagnosis. I think I missed a slide there. You are providing an opinion to the court, and then it's the court that decides whether or not that person has capacity. Okay, I thought I missed a slide, but I'm not sure. You're welcome. Capacity assessment itself means an assessment of the adult's ability. Sorry, I'm not sure why my computer's doing this, but it's really slow transitioning the slides.
Okay, it's good on, you know what, it's bothering you, but we're fine.
Okay.
We'll just motor through. It's all good.
Gives my voice a little chance to catch up in between.
Sure.
So capacity means, darn it. There we go. So capacity assessment means assessment of an adult's capacity to make decisions respecting personal matters and financial matters. So that just goes along with the definition of capacity. I have never had this happen before.
Well, if it's going to happen, it'll happen because I'm here. So.
It usually will, because I am too, trust me.
It's all good.
So there are certain events that will trigger the reason for a capacity assessment, and we want to make sure that there's been a trigger. So something that happens in the person's life, something that changes, it might be a brain injury or an accident or a stroke, a person has dementia. It may be a person turning 18 that has been under Child and Family Services Authority or services to children with disabilities programs. So we need to make sure that there's some kind of a trigger or circumstance that potentially could place that person or others at risk, and then necessitates investigation into whether they need a decision maker appointed by the court, or whether there's some kind of problem solving we can do in the first place to mitigate that need for having a decision maker appointed. And this is where sometimes we have differences between families and maybe the physicians or the medical field where, or the medical field and the public guardian's office, where they feel the person needs to have a decision maker right away. And we're saying we need to see what the reason is first. And maybe the person is acutely mentally ill. That's not the time that we want to make an application or do a capacity assessment for sure. And one of the things that I do a presentation once a year for fourth year medical students, along with one of the physicians I work with. And we talk about the fact that a person might make risky decisions regularly. That doesn't necessarily mean they don't have capacity. It just means that they make risky decisions. But if they understand what the consequence of that decision is, then they're making that decision consciously and not because they don't have the ability to understand what they're doing or what the excuse me, what the consequences are. Some of the things that an individual has the right to have done or not done, they have the right to have the assistance of either a language interpreter or an assistive technology device with them, or a sign language interpreter if they need that to help them communicate during a capacity assessment. I recently just had some conversations with some people up in this area in Edmonton that didn't want to use language interpreters because they didn't feel comfortable that they were getting the right information. But that person has a right. If they can't understand you speaking English and you don't speak their language, they have a right to have that language interpreter there. What we don't want people doing, though, is using family members as the interpreters, because then you don't know. If you don't understand the language, you're not sure what that person is saying. So we want it to be an actual interpreter in service of language interpreters. The next one is that capacity assessments should be completed at a time when the adult is likely to be able to demonstrate their full capacity. And that again was, like I said, if the person is acutely mentally ill, that's not the time that we want to do a capacity assessment because they're not at their best. We don't want to do an assessment on an alcoholic that is detoxing, or, I mean, you probably don't want to do it when the person is drunk, but maybe that's when they have the most ability to make their own decisions. So you want to do it when they're at their best to be able to show you what their capacity is. So that's part of where your collateral information gathering comes from. Talk to somebody that knows the person, knows when they are generally at their best. Some elderly people or people with dementia might do really well in the morning, but they sleep all afternoon. So you don't want to go and do that interview with them when they're in their sleepy mode in the afternoon. You want to do it in the morning. So do a little bit of work first and find out when the best time is to do that assessment, not necessarily when it works best for you or for other people. And like I was just saying, you want to make reasonable efforts to obtain any information that is relevant to that person and to the assessment of their capacity. Talk to their family. You might want to talk to their neighbors if it's an elderly person living alone. talk to their partners, talk to physicians, the social workers that work with them. Home care staff are one of our biggest resources when we do capacity assessments because they go in and out of that person's house all the time. Oh, I'll drink my cold coffee in between waiting for slides to change. So, oh, I just missed that question. Can a parent access a capacity assessment? We'll get to that question. There was a question just before that, and I can't see the chat to see what the question. Oh, just a second here, I guess. Here it is. Have you experienced using translators when abuse has occurred? And if so, how do you mitigate cultural impacts being expressed, values and biases? I'm not entirely sure what you mean by that, Lori. Abuse by the interpreters or the translators? So I'm not, if you could explain that a little bit more what you mean there, and then I'll answer that one.
Sure. Sorry, Melanie. I was just wondering, like in family violence issues, using translators, we have to be sensitive to how things are being interpreted so that the cultural impacts that in some groups abuse is not seen the same as it is here in Canada. And so with doing an assessment with someone, and if they were experiencing abuse, like, is that taken into consideration, and how do you mitigate that through a translator?
No, that's a really good question, and I'm not sure that I entirely have the answer, but one of the things I always talk about at the training is to be aware of the cultural differences, and that what we might see as abuse might not be what they see as abuse because it's part of their culture, unless the person is being, physically put at risk. But we do definitely want to take cultural differences into account, which is why one of the reasons why we don't want family members to be the translators, so that we make sure we're getting that individual's answers, and that we use translators that we try. I think the assessors would want to use a translator that is from that same culture, not necessarily that they just know the language, but that they're from that culture. We don't want their opinions being offered, but they, I think, would make the person more comfortable and feel more comfortable expressing themselves to somebody that's from their own culture. And they're not always easy to find. I had to help somebody called me the other day looking for a Thai translator. There's not a lot of Thai translators certainly not in Edmonton. We had a bit of a struggle finding someone, but it's one of the things I also ask for a list of from all of our capacity assessors is, what languages do you speak? And that makes a big difference sometimes. If the assessor can speak to them in their own language, I can't make referrals to specific capacity assessors, but I can say, I know these 4 people speak Spanish. That's quite often one that we need, or an Asian language, Mandarin or something like that. So if the assessors speak that language, I might say, you might want to call this person because they know how to speak that language. So I hope that answers your question. Just while I'm waiting for the slides to change, I'm just looking to see what other questions we have.
There is one here from Judy. Can a parent access a capacity assessment on behalf of an FASD adult who will not help themselves?
So when you say access a capacity assessment, do you mean can you explain a little bit more what you mean by accessing the assessment? Do you mean the completed form or getting the assessment in the first place?
Well, thank you for taking the question. I actually have an individual. She has 3 adopted FASD adults. All 3 have moved back in with her because they're not able to function. And this is timely. She's coming in later this afternoon, and she was asking about, you know, accessing a capacity assessment. Would she be able to, if her son were to agree to a capacity assessment, which that may be the difficulty in itself, but if she could, would you be able to perform one? Because he's not doing well. In fact, she has 2 sons, one 23, 24, and neither are doing well. They've both been to jail already. They're both, you know, falling through the cracks. And she doesn't have the documentation she needs, you know, to access the support that would benefit them.
So she can certainly try and get the capacity assessment for him. It's usually somebody else that will arrange that assessment. The problem being that that person can also refuse to have the assessment if they don't want to have it done. And then the mom would have to ask for a hearing in court to have the judge tell the person that they have to have the assessment. And I completely understand where she's coming from, because my daughter that I said has developmental disabilities is adopted and has FASD amongst other things. And, you know, we were lucky with me being in this profession that it was a little easier for me to get a capacity assessment done for her. But a lot of times those FAS kids that are, you know, 17 going on 45 think they know how to live their own lives, and they'll refuse to have everything done. So, you know, good luck to her getting it done. And sometimes it'll take a couple of tries before she can convince them to have it. And if she can even get them to meet initially with the assessor, then
we'll just let her know you'll come get it.
That might be enough to get them to agree to the assessment.
Well, I appreciate you answering that. I also fostered for 9 years, so I've experienced that on the other side of it. And it seems to me that the persons that are affected, they really struggle to, you know, receive the assessments they need in order to access the supports that would benefit them. So I'm always asking questions.
Yeah, it was, you know, as much as I think I know about all of these systems and professions, it was different being on the other side of the coin, let me tell you.
Well, thank you so much for that.
You're welcome. I can't seem to get my slide to change here now.
Okay, let's see if I can help you out. Oh, there it went.
Oh, whatever, I can see your mouse moving. Oh, there we go.
Okay, sorry.
I think I might have missed one in there, but I think we just basically talked about it. It was the person's right to refuse to have that assessment done. And if that person is in the middle of the assessment, they also have the right to have a person that makes them feel comfortable in the room with them. That may or may not be the parent. Oftentimes it's not, or I know that I've heard of assessors having an abusive spouse come in and want to be part of the assessment, and that assessor has every right to ask that person to leave and to not allow them to be part of the assessment if they're going to interfere. If there's going to be somebody there, they're expected to be there just as a comfort, not as the one answering the questions. One of the assessors in Calgary that I talked to said he would see the husband kick the wife under the table each time a question was asked to make sure she gave the right answer, and he was asked to leave. And sometimes they'll kick up quite a stink about leaving, but you want the person to be as comfortable as possible when they're having the assessment. So they have that right to have somebody there, but they also have the right to discontinue that assessment if they get there and they decide they don't want to have it done. And if that happens, the assessor should be stopping and not completing the assessment at that time. they may try again, and they may be able to go back to it, and the individual might agree then to have it. Sometimes, you know, any of you that work with seniors, most senior men that are kind of what I would call the grumpy old men group are going to say, no, get out of my room. You're not doing you're not talking to me at all. So sometimes you have to come at it a different way, because you do have to tell them why you're there. You have to let them know what the assessment is about. But sometimes it's, you know, start talking about something they're interested in, like hockey, or just kind of break the ice instead of storming into the room with your clipboard and saying, this is what I'm here for. And most assessors wouldn't do that anyway, but just to caution. Just trying to keep track of some of the messages here. Oh, somebody had to leave for so the next slide is who has access to the capacity assessment report, and we get this question a lot. Once you've done that capacity assessment, where does the report go? So the applicant is generally the person that asked you to do the capacity assessment in the first place. That might be the parents of a child. It might be children of a senior that needs an assessment done. If they're the ones that requested that assessment, and if you're doing it as private practice and they're the ones paying for it, they own that report once you're done doing the report. The person that the report is about also has a right to have a copy of that assessment report. The review officer from the Office of the Public Guardian and Trustee will also get it as part of the application package. So it's part of the bigger court application, and all of those applications will come to the Public Guardian's office, and the review officer will see that report. And then of course it goes to the court because it's part of the application, and that's what gives the judge the most information about the person's capacity and whether they're going to need a decision maker or not. So you're providing an opinion in your report, and the court's going to look at that opinion and decide whether or not the person gets appointed the guardian or the trustee or the co-decision maker. People that do not have a right to have that report are other family members. This is often a big problem for capacity assessors, especially when it's separated parents who both want to apply for guardianship, or siblings want to see the report. The only person that can give them that report at the time is the applicant, or they can request a hearing through the court. And if they request a hearing, then they will get a copy of that report as well. Otherwise, they have no right to have that report. They very often think they do, but they don't.
Did it stop again?
Yeah, it's
just creating all kinds of trouble. Hey,
yeah.
Do you want me to try from my end again?
Yeah, please
Okay.
do that.
Okay, let's see if I can get it to go. It changed on our end, or my end, so you should be.
So it probably
seeing it right
will here.
away.
It just needs a minute.
Okay.
There, it's coming. I can normally do these kind of in my sleep anyway, so I could probably go through the slide.
I'm sure you can.
My husband asked me this morning how many times I've done this presentation, and I couldn't even give you an idea.
I bet.
So one of the questions that we get a lot, and when we first introduced this act, especially physicians were saying, no way, man, I don't want to do these because I'll get sued. In that time, when 2009, when everybody was getting sued for everything they did, said, and wanted to do. So a lot of physicians and other professionals were refusing to do capacity assessment. So I just put this up as what the Act says about liability, and that no action lies against the public guardian, a capacity assessor, or a review officer, and there was some other people named in there, for anything done or omitted to be done in good faith in exercising powers or authority or carrying out duties, responsibilities, or functions under this act. So I don't think that there's a worry about being sued. I haven't heard of anybody being sued. You can get called to court if you do a capacity assessment because a judge may want to ask you more questions. I've had family members call me and want to have the capacity assessor fired, which is really not my ability or responsibility to do because they don't work for me, they work for their own organizations. But oftentimes people will, parents will ask you to do an assessment and they want you to say what they want in the assessment. And that's not what you're doing. You want to assess the person and make your determination on what you see and what you hear from the individual as to whether or not they have capacity. And many parents get really angry about that if you come back and say, well, my opinion is the person has capacity. And they may then capacity assessor shop until they find somebody that will say what they want. So, being sued or being, getting in trouble, as long as you've done it in done the assessment in good faith, then you don't really have anything to worry about. Do you want to try again for me, Charlene?
Yeah, you bet. There is there's a question in chat too. How would someone go about finding a capacity assessor?
So we have a roster on the internet. There's two basically different kinds of assessors. One group does assessments under a private practice. So they have their own company and will do assessments that way. And the other group is people that do them just for their employers. So hospitals will send their social workers and OTs and some nurses, and they can only do assessments under that hospital umbrella. So we have two different rosters. One is for private assessors on our website, and the other one is for people that just do them for their employers. The reason that we have the ones that do them for their employers is not so much for the public to find an assessor, but sometimes a doctor will phone and say, who in the Royal Alex Hospital in Edmonton can do assessments? I need to find somebody. So they can look under there. But the other roster is for the everyday person that needs an assessment done to be able to look at that roster and call an assessor to do an assessment.
Melanie, are those lists on the internet, are they updated regularly?
Yeah, anytime that somebody has a change of information or has information to add or wants their name added or taken off, they send it to me and then I send it up to the web managers. I can't change things myself on it. I have to send the names up to them. Oh, sorry, cat sitting on my keyboard.
Okay.
I send it to them and they change it. The delays usually are caused by me sometimes because I don't send up one request at a time. I try and gather up as many as I can. We switched over to using alberta.ca and they're a little tougher to work with. They don't do things quite as easily and quickly as our last group did. So sometimes it takes me a little while to get the information updated on there, but I do as much as I can keep it up to date. Sometimes people leave the profession or don't do assessments anymore and they don't let me know. So I don't know to take their name off the roster until they get mad because people are calling them and they don't want the phone calls anymore. So we do what we can.
Awesome.
So one of the questions that people had been asking is about fees for capacity assessments. The fees are regulated again in the AGTA regulations, and this is just for co-decision-making, guardianship, and trusteeship assessments. A private assessor can charge $500 for co-decision-making assessment, $500 for guardianship only assessment, $500 for a trusteeship only assessment, or $700 for a combined guardianship and trusteeship assessment. This has always been a bit of a bone of contention because if you're in private practice, $500 is nothing for the amount of work that you sometimes have to do to get these assessments done. On the other hand, you're often dealing with people who are on a very, very, very minimal income, like AISH or seniors pensions, and $500 is a lot of money. Even when we did it for our daughter, $700 was a lot of money for us to come up with at one time. So, the fees aren't very much, but on the other hand, they're a lot. We did try and raise the fees just a little bit when we did the regulation review, and we were denied. They wouldn't let us raise the fees because it's a hardship for a lot of people to pay those assessments. Physicians sometimes, even though I don't believe they're supposed to, they will charge in their clinic fees to do the assessments, just like they'll charge you to do any other kind of paperwork. There's not a whole lot we can do about that. The College of Physicians and Surgeons would have to regulate that somehow. And assessments that are completed while a person is in a facility or in acute care do not have a fee. So if you just do assessments within the hospital that you work in or the long-term care center, you do not charge the person a fee to do it. That's part of your job. Okay, do you want to try and change that for me again?
Yeah.
Okay, so that was all of the information kind of about the guardianship trusteeship part. And now I'll talk a little bit about the Personal Directives Act, because again, like I said, it's a completely separate act. Even though we work under both acts, they are not combined acts and they do not do things in exactly the same way. Next slide, please. So capacity is defined almost exactly the same under the Personal Directives Act as it is under the Guardianship and Trusteeship Act. But a personal directive is a voluntary document that a person makes while they still have capacity. So if they already don't have capacity, they're not likely to make a personal directive. But while you have capacity, you make the document that chooses who you would want to make your decisions once you lose that capacity. And then that document sits there until you do lose capacity, and then it comes into effect. Next, please. So the definition is the same. The difference is that in a personal directive, the maker, the person that writes the personal directive, you're now assessing to see if they've lost capacity. In a guardianship capacity assessment, you're seeing if they have capacity to begin with, not whether they had it before and they've lost it. In a personal directive, you know that they did have capacity, so you're assessing to see if they still have it or if they've lost it. Personal directives address personal matters, non-financial, so nothing related to their estate, nothing related to financial. That is an enduring power of attorney, which is again a separate act. We do not have any authority under that act. It's not one that we work under. It's a different act. It's under different programs than ours. So we don't have any authority to do anything under the Power of Attorney Act. There's not forms for it. It's its own act. It's an old act that we're really hoping we can get changed, but we've had not much luck doing that. It's a very arduous process to change an act, and it really needs a lot of change. And again, as the complaints officer, probably 7 out of 10 complaints I get are related to power of attorney, and I have no authority to do an investigation under power of attorney. Personal directives and powers of attorney in this province are not supposed to be combined documents. We do see them occasionally. And as long as the personal directive part addresses personal issues, we can make the exception that they can be used, but they're really not supposed to be. A personal directive from another province can also be valid in this province, provided it doesn't contravene any of the Alberta laws. That makes it really complicated because they're very different in every province. Every province has their own legislation. Most of them are called power of attorney, not a personal directive or a health. Sometimes they're called a health directive. Often they are a combined document. The ones from BC are called representation agreements, and they're very difficult to try and compare our legislation here. So we have to look at them really carefully to see if they actually do coincide with our laws here. Let's see, did I cover all of that? Okay. There's a question that says who can review the power of attorney or the personal directive if they're not being followed. For personal directives, as the complaints officer, you can make a complaint to me. It has to be in writing and signed, and then come to me and we can look at it and see if we can do an investigation. Power of attorney does not have that ability under that act. It has to go to court. If there's issues with it, the person has to go to court and ask a judge to overturn it or to look at it or to ask for what they call passing of accounts, to look at what the power of attorney's been doing with the money. Can you switch that? Did you try and switch that one, or did I?
No, not yet. I just switched it now.
It says police have the authority to investigate a power of attorney. They may have the authority, but you'd be hard pressed to get them to do it unless there's some really severe financial abuse and really good evidence of it. And 9 times out of 10, what they say is go phone the public guardian's office. And then that's what when they phone me and want me to do an investigation, but they really don't do much of an investigation when it comes to power of attorney that I've ever seen anyway. Back to personal directive writing. When they're writing a personal directive, or when you're writing a personal directive, it should be someone that you trust, that you know will make the decisions that you would have made when you had the ability to make those decisions for yourself. And like I said, you want the personal directive the personal directive will remain dormant from the time they're written until you've had a capacity assessment that says you no longer have capacity, and the directive then becomes enacted. Some provinces, again, BC, will put a clause in theirs that says that they are in effect as soon as they're written. That's not the way we do it here. And the whole point is that we want people to write them when they know what they're doing, who they want to make their decisions, and then it's there when you need it. It's the same as doing a guardianship application at 17. Then we know it's in place by the time that person turns 18. The problem often comes, and when I see them as complaints, is somebody that has more than one child, and they'll either name all of their children as their agents to act together, who can never agree on anything and cause all sorts of trouble, or they'll name one child and another child will say, but I know mom wanted me, not my sister, and again, cause all sorts of problems. So a lot of personal directive complaints are families fighting amongst each other. The maker can name more than one agent. They can technically name, I think, however many they want. They can either have one agent, they can have more than one agent and say that they want them to act jointly, or they can have a primary agent that is the main decision maker. And then if that person is no longer willing or able to make decisions, then they have an alternate agent name that takes over. We try and really promote making it as clear as possible in their personal directive, because oftentimes one of the jobs I have as a complaints officer is really trying to interpret what they would have meant. And we can't make assumptions about what they meant, but if they're not clear, it makes it really difficult for anybody to understand. In a personal directive, they can also name the areas, and the domains are the same as for guardianship. So healthcare decisions, where the person lives, who they associate with, what social activities they can take part in, whether they can take part in education or training, and legal decisions. So you can name one agent for all of those. You can say, I only want my agent to decide where I'm going to live and look after any legal matters. Those are the two most common ones we see, and health related decisions. Or you can just make a blanket statement that you want them to have authority in all areas. And hopefully, if there's something that the person really strongly believes in, they'll put that in their personal directive so that it's more evident, because then again, when it comes to a complaints process, we can say, but that's what the person wanted and you need to act under what they want. Next slide, please. I was just going to say with that last one, many times people don't name an alternate agent, and that also makes it a little bit tough. If that agent, people will often name their spouse, and if they're a senior and their spouse is a senior, then the spouse may even lose capacity before they do, and then there's nobody else that's named, and you cannot just replace that person with somebody else. Only the person that made the personal directive, if it's not enacted, can change it and put somebody else in as their agent. So we really encourage people to put an alternate agent in. And when we changed, we didn't repeal this whole act, we just changed it, a lot of it in about 2008, I think it was proclaimed. And one of the things that was added in was that the public guardian can act as the agent, not as the alternate agent, just as the primary agent. So if they don't have any children, or if they don't like their children, if they're separated from their spouse and don't want that person to make the decisions, they can ask the public guardian to do it. But the public guardian has to sign consent to act as their agent. So the forms that we use for capacity assessment for a personal directive get a little bit complex, and this can be really a little bit confusing. But in a personal directive, you can name the person that you want to determine your capacity. So you might say, I want my agent to determine my capacity. If you put that in there, the form that's completed is called a Schedule 2. So anything under the Personal Directives Act is called a schedule, not a form. It's Schedule 2. And the person that you've named completes Part 1, and then a physician or psychologist has to complete Part 2. If you don't name someone, then it's called a Schedule 3, and a physician or psychologist has to complete Part 1. And a second service provider, which can be another doctor, it can be a nurse, a facility manager, a social worker, another physician, they're the ones that complete Part 2. It doesn't have to be a second doctor. It can be one of those people named. And if you read the definition of a healthcare provider in the Act, it will tell you exactly who can do that. I think I answered this question already, Leah, that you had on here. Can a person with a personal directive enacted ask for a different agent once it's already enacted? There's a bit of controversy over that, because to write a personal directive, a person doesn't have to be able to make all of their own decisions. They have to only be able to know, I want this person to make my decisions for me, and these are the decisions I want them to be able to make, and they need to be able to retain that. And then when you go ask them tomorrow, they still say, I want the same person to make my decisions for me. So there's a lot of, I think, gray area there when you ask if they can change it once it's enacted. Lots of lawyers will do it if they go to them and ask for it to be changed, and lots of lawyers won't. That's why we sort of encourage people to use a lawyer, but it's really, I can't give you a black and white answer on that, except that the threshold for having the ability to make a personal directive is different than the threshold for removing their ability to make any of their other decisions. So I hope that makes sense. Next slide, please. We haven't just until 2:30, right, Charlene?
Yeah, that's right. So we're on slide 30. So I think you had 32 slides or something. So I think we must be coming forward.
Yeah, I think we're pretty close to the end.
Yeah. Yeah, no problem.
You can go to the next one.
Okay. The next one coming up is important terms to know.
Okay, so these are the last two. No, I see just. So there was one just before that.
Oh, sorry, I'll go back.
Yeah, just go back one.
Okay. It should be loading right away on your end.
And it was just basically a bit more about the capacity assessment part. And the assessor does need to go and see the person for a personal directive in order to make that determination. We get a lot of arguments about this between social workers and doctors, and a doctor that hasn't seen the person in a long time can't just say the person doesn't have capacity. They need to have seen that person, and a personal directive enactment also needs to have that medical assessment to say, do they just have some kind of an illness right now that's preventing them from being able to make decisions, and let's wait for a bit and see if it clears up and if they are doing any better. The Personal Directive Act also has the portion of it where an enacted personal directive may be then reversed if the person has regained capacity, and there's specific schedules to fill out for that too. This is also one that people don't like to do because they don't like to give back a person's rights once they've been removed to make those decisions. And families will fight about this a lot. One will say, well, I think dad's better and he can make his own decisions. And then the next child says, no, he's not. He doesn't have that ability. So, you know, but they do have the right to be reassessed if there's been a change in their capacity. An agent cannot just resign from being an agent. There needs to be a decision maker in place, because if that's an enacted personal directive, then they're the person legally responsible for making those decisions. And if they quit doing that, then there's no decision maker in place, and that person still doesn't have capacity, but who's making their decisions? So this is fairly new, but what our legal team has figured out and been able to discuss with some of the justices is that a person who is an agent and wants to resign from being an agent needs to have somebody else applying for guardianship or trusteeship to take that to court and overturn a personal directive. Or if somebody disagrees with a personal directive, they can take it to court and ask for it to be overturned. But there has to be then another decision maker being put in place, and it can't be another personal directive, because the maker of the personal directive can no longer make that decision if they don't have the capacity to do it. If there's an alternate agent named and the primary agent has either lost capacity themselves and can't do it anymore or refuses to do it anymore, the alternate can take over. But if there's not an alternate, then somebody needs to take the personal directive to court and have a guardianship application put in place of it. And I have lots of times when siblings will phone and say, well, can't I just be added as an agent on it now? If it's enacted, no, you can't just add. The only person that can add somebody to that is the person that made the personal directive in the first place, because they're the ones choosing who they want to make their decisions. Okay, and then the last two slides are just some terms that I put in there for you to read. And I think we'll save the last little bit for the last few questions if we have them. They're just terms that sometimes people get confused on, so I thought they'd be important for you to be able to see them. So I won't
Sure.
go through all of them and take the time.
No, that's great. And they might be things that people can, you know, in order to understand them, you need to read them over a couple of
Right.
times and try
And
to.
I really do encourage people to read the acts and the regulations just so
Right.
that you get that. And lots of times, even when a DCA will phone me and want to know an answer to a question, I'll say, look at section so-and-so of the act, because that way it gets into your head more what it says. And then on this last page, we have a capacity assessment email now that's dedicated just to capacity assessment questions and for the DCAs. And then that's our website for, that's where you can find the roster of capacity assessors.
That's awesome. I'm just wondering, I'll just go to the next slide here, which will wrap things up. And before I do all of my kudos and wonderful thoughts about everything you've done for us today, thank you, Melanie. But I have a question too, is along that line of the act. Is there like a cheat sheet for the act? I mean, when I read through the act, it's kind of legalese, but is there like an easier layman's version of the act?
I think I do have a couple. So if you send me an email and ask me about that, I'll send them to you. I use them with the training sometimes, just
Okay.
you know, if you're not familiar with looking at legislative acts, it can be a little bit daunting
Sure.
to do. And believe me, our act is 1,000% easier to read than some of the other provinces. I'm from Saskatchewan, so I was curious to read because I wanted my mom to do some documents and I could not get past the first page. It was just,
Oh, good Lord. Well, if you couldn't get past the first stage, I can't imagine anybody else being able to. And I'm wondering if then whatever you email to me, we can attach to the evaluation and anything else that you might want to add to have for people to access.
Sure.
Along
Yeah.
with that too.
Yeah, I'll add some things in that will be helpful.
That's awesome. I want to open it up just for a minute. I know we're right at 2:29, but if anybody has any last minute questions or comments that they have, I invite you to either throw them in the chat box quickly, or if you want to raise your hand and we can take a couple of questions before we wrap up. So I'll just let people have an opportunity to do that. But while people are kind of organizing themselves to maybe do that, I want to just encourage anybody on the call today to go into the Core Alberta website platform and join the elder abuse group if you are not already. We look forward to having these kinds of really rich presentations and conversations within that platform. So if you're not already a member of that group, I invite you to do that. And Cindy has thrown in the Core Alberta link. Cindy, do you want me to just continue with having the conversation here? Did you want to jump in at all?
I think I can quickly share my screen if you allow me, and
Sure.
I can show them the website and maybe where to go to join, and then perhaps you can talk a little bit about the discussion thread that you might want to invite people.
Yeah.
Perfect. Yeah, so this is just the homepage of the Core Alberta platform. There's a lot of resources and programs that are available for you to refer to. If you want to join a core group, we invite you to create a membership. Here I am logged in. You can just go into the groups tab, and then I believe the elder abuse group is on the second page. You would click go. And then we have a featured discussion around capacity assessments just based on today's presentation. We would love for you to add to that. And this can inform our future training opportunities and events. If you join the group, you get looped into future events generally anyways around elder abuse. So it would be a really great opportunity for us to continue these important conversations. I will leave the link to the discussion thread in the chat as well as a survey link. We would love if you can take a little bit of time to let us know how your experience was today. And I'll let Charlene talk a little bit more about the discussion thread if you have anything to add.
Sure, thank you for that, Cindy. Yeah, really just to wrap things up, the discussion thread is, it was kind of like a brainstorming thing, that conclusion that we came to when we were planning this session, that there just is always a lot of questions that come out of capacity assessment presentations. There's always questions and comments, and I think that this would be a good way for us to kind of keep track of people, you know, if you have questions, and we can perhaps build more training sessions. And I'm hoping that Melanie can maybe give us some feedback on that as time goes by too. So yeah, look for that discussion thread within that Core Elder Abuse platform. Just want to wrap it up because we're right at 2:32. Thank you everybody for joining us today. Thank you for the Core team for joining us. A survey will be sent out with an evaluation in a follow-up email early next week, along with hopefully something that Melanie can send along with us to share with everyone. Melanie, thank you so much for joining us today. It was an absolute pleasure, despite our technical
it's the story of my life, let me tell you.
The way things go, we're all getting used to. Even after a year of doing this, there's always some things that test our patience, but this is a wonderful group to belong to, and people are pretty relaxed that way. But I do truly thank you very much for the presentation. Great information. If we could download your brain so that we could have a really firm understanding of all.
You do not want to do that, trust me. You don't want to know the other crap that's floating around in there.
Okay, well, that's good to know. We'll just take the handouts from you then. So thank you so much. And again, everybody, this session was recorded. So if you want to go back and listen to it again to get some of that information again, you're more than welcome to do that. Our next session will be at the end of March, which will be on the topic of elder mediation. And so look for that going forward in the elder abuse discussion in the elder abuse platform. So thanks, everybody. Have a great weekend. Stay warm, stay well. Blessings to everyone.
Thank you.